This is our straightforward 6-minute overview of the Renters' Right Act, the biggest shift in the private rental sector in more than 3 decades. I'm Adam from Orchards and I've been managing properties for landlords for 15 years as part of the biggest independent agent in Bedfordshire. Let's look at what's changing, when it's happening and what landlords need to be prepared for. The first rule change happens in December, long before the tenancy reforms kick in. From the 27th of December 2025, local authorities receive a new set of powers for investigations and enforcement. This includes the ability to demand documents immediately, expanded rights to enter and inspect properties without a warrant, stronger access to third-party data, and a wider scope to issue financial penalties, all without a warrant. For landlords, this means compliance baselines raise immediately and the margin for error becomes much smaller, months before the bigger reforms start. Now this is where the heart of the Act switches on. Section 21 ends permanently and all possession routes now fall under Section 8. This means you must rely on specific grounds, some mandatory and some discretionary. And the quality of your evidence now becomes the deciding factor. The accelerated possession route disappears entirely, and if a tenant chooses not to leave, every possession claim now requires a court hearing. To put this into perspective, last year, around 40,000 Section 21 notices ended up in court. These cases won't go away, they're simply pushed into a slower, more complex process that impacts both landlords and tenants. No fixed terms, everything becomes periodic from day one. And that gives tenants flexibility, but it removes the option of a long-term tenancies. One of our long-standing tenants asked if they could move to a 2 or a 3-year contract so that their children, now that they're settled in the local schools, could decorate their bedrooms with a little bit more personality. Normally, that would be something that a landlord and tenant would be very happy to do, but under the new system, that can't happen. The tenancy will always be periodic, and the landlord will always be able to regain possession with 4 months' notice if they need to sell or move back in themselves. So the very people who want long-term stability on both sides now simply can't create it. Rents can still only increase once every 12 months. That part isn't new, but the process is completely different. All increases must be carried out through a Section 13 notice, and tenants can dispute this increase for free through adjudication. This delays the start of any increase and requires the landlord to provide genuine comparable evidence. Realistically, if a tenant can challenge an increase at no cost, many will. This is where using a letting agent becomes extremely important, because we hold private comparable data that isn't publicly available. For example, the rent paid by a property 2 doors down or the one across the road, if we manage it. We'll have that information and no one else will. That will be crucial and can be the difference between an adjudicator approving your increase or reducing it. Landlord and agents can't ask for or accept offers above the advertised rent. This will almost certainly result in higher advertised asking prices because the rent price becomes the maximum allowable figure. Landlords cannot refuse inquiries or viewings based on children or benefits. To stay compliant, landlords now need a clear and well-documented understanding of affordability criteria, referencing limits, and overcrowding rules, especially as multi-generational households and larger family units become more common. Tenants can now request a pet, and landlords have 28 days to respond and must have a valid reason to refuse. Not complicated, but another process that must be followed correctly and documented clearly. This is crucial. The penalties landlords face are significantly increasing, with civil fines of up to £40,000, unlimited fines for certain criminal offences, and rent repayment orders of up to 12 months' rent. And in the most serious cases, potential imprisonment. Combined with council's new powers from December, landlords without strong compliance systems or a capable agent will face much greater risk. From late 2026, every landlord must register each property on a new PRS database, pay an annual fee and upload property details, safety certificates and compliance information. This makes the gaps in compliance immediately visible to local authorities who, as we've already covered, have an increased ability to enforce. Landlord Ombudsman becomes mandatory and every landlord must join. This creates a simpler route for tenants to raise complaints, but also increases the volume and complexity of cases landlords will need to respond to. The next wave of reforms include the Decent Home Standard being applied to the PRS, Awaab's law introducing strict repair timescales, and a full review and modernisation of the Housing Health and Safety Rating System, HHSRS, and updates to the minimum energy efficiency standards. These reforms will significantly raise the minimum standard expected for every rental property. So that's the Renters' Right Act in 6 minutes. Some parts are totally sensible, and some parts will create real challenges. Our job is to help landlords and tenants navigate these clearly, accurately, and with systems in place to protect both of you. I'll be covering each one of these sections in dedicated videos with lots more detail, as well as publishing our Landlord's Guide, which will be linked in the description.